5 seconds to go. Start. The learned judge erred in failing to appreciate that the fraud was consummate and involved a complex subterfuge, spread over a long period of time. Stop. The accused directors sat in subcommittees that negotiated and earmarked without any shareholder authority, the NCDs with warrants convertible of shares with a sizable free allotment of bonus shares to allottees of the NCDs, which were essentially paper companies and related companies of the accused, and later on joined them as person acting in concert when the warrants attached to the NCDs were converted into shares in 2000. Stop. When the directors negotiated the placement of NCDs with warrants with the Unit Trust of India, whose allotment is made as per Resolution 13 as disclosed on the stock exchange, no such free bonus was given to UTI. Stop. However, all this was not considered by the learned judge, who erred in failing to appreciate that the directors also granted a conversion price to the accused allottees, which was much less than the conversion price given to UTI. Stop. Para. The learned judge erred in failing to appreciate the ratio laid down by the Honorable Supreme Court in the matter of Shri Khande versus State of Maharashtra and another, 2013, 14, Supreme Court cases 44, wherein, the Honorable Supreme Court has held that at the complaint stage, the magistrate is merely concerned with the allegations made out in the complaint and has only to prima facie satisfy whether there are sufficient grounds to proceed against the accused. Stop. In the facts of the present case, there were more than sufficient grounds for the learned judge to prima facie be satisfied of the offence and issue process in the matter. Stop. Para. The learned judge failed to note that it was vitally necessary to take cognizance of the offences in the interest of justice under section 473, keeping in mind the devious method of involving 38 companies and routing of funds in a pre-planned and preordained sequence of transactions. Stop. If no cognizance is taken of such egregious offences, it would seriously harm the interest of the investors in the securities market. Stop. It is in the interest of justice that large conglomerates having lakhs of shareholders are not permitted to flagrantly violate the law and seek to escape prosecution. Stop. Para. Coming to the point of delay, inter alia, the contention of SEBI is that the court should have considered section 473 of CRPC to condone delay, having considered the facts and circumstances in proper perspective. Stop. At this juncture, it is relevant to quote section 473 of CRPC, which reads as under, para. Notwithstanding anything contained in the foregoing provisions of this chapter, any court may take cognizance of an offence after the expiry of the period of limitation, if it is satisfied on the facts and in the circumstances of the case. Stop.